Hey, what's up, guys? This is Adam from Rescue Michigan, and in this video, we are going to be looking at Lucas Gerhard's appeal to the Michigan Supreme Court. We've talked about this case on several of our other shows. It's a case I've been involved with since even before we started the Rescue Michigan Coalition. At the time, I was a legislative assistant for Representative Riley, and Lucas Gerhard was one of his constituents. He was arrested and charged with making a terrorist threat, which is a 20-year felony in Michigan, for posting a photo of his lawfully owned, lawfully obtained rifle on Snapchat and joking among friends that it would make snowflakes melt. On that basis alone, a snowflake that was not a recipient of the post reported it to campus police, to local police. He was charged by the county prosecutor, thrown in jail for 83 days, and has been in some form of detention for the past 2 full years now. He's been under house arrest ever since being released from jail. He's been unable to go to school, unable to get a job, unable to go onto the internet, even unable to have a smartphone. So 2 years of his life was destroyed. And most recently, the Michigan Court of Appeals upheld all of that and refused to dismiss the case and said that there was a new standard established, that of impossibility of his guilt, and failing that, he would have to be brought before a jury to determine whether or not his speech was protected under the First Amendment. It was an absolute miscarriage of justice because it's clear First Amendment case law from the U.S. Supreme Court that questions of what constitutes a true threat are a question of law, not a question of fact. They're to be decided by a judge, someone who's legally competent, not a jury of one's peers. But nonetheless, Lucas is going to have, he has an appeal filed now in the Michigan Supreme Court. And this coming Tuesday, October 19th, there's actually going to be a hearing in the State House on legislation to clarify what the definition of a terror threat is. So we hope that legislation moves forward. We hope it also brings attention to this case because what the Court of Appeals says really goes for everybody, and what's happened to Lucas now can happen to anybody. That's currently what the interpretation is of the First Amendment in Michigan. It is a terrible travesty, and hopefully the Michigan Supreme Court will take this case up and reverse the Court of Appeals. But I want to take you through Lucas's appeal and really get into the legal issues that are being presented here. So this is the motion. It's a application for leave to appeal filed with the state Supreme Court. So it's People of Michigan v. Lucas Gerhard. His attorneys, Phil Ellison and Matt Granda, they've actually appeared on our show here before. So you can, if you go to our channel on Rumble or YouTube, you can scroll down. Eventually you'll find that interview. But this is newer. This was filed August 19th. So the attorneys are hopeful that there will be a decision probably sometime before the end of this year. And let's go through this. There's a table of contents here. You can see the arguments are going to be that the statute under which he was charged is unconstitutional, and even if not, it was an abuse of discretion for his case to be bound over to circuit court. We'll explain what that means when we get there. And then there's a table of all these cases that are going to be cited, and the statutes. So anyway, statement of jurisdiction is pretty minor. We're appealing to the state Supreme Court. That's who hears appeals from the Court of Appeals. So there's no jurisdiction issue there. And here is where they're asking what they want the state Supreme Court to consider. So number one, under United States Supreme Court precedent, only a true threat can be criminalized. A true threat is a, quote, serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. And that's not what the terror statute says in Michigan. So we'll look at that in a moment. But they say, as they describe it here, criminalizes threatening speech irrespective of intent, therefore facially unconstitutional. Question number two, a district court must find that a felony was committed in order to bind over a defendant for trial in the circuit court. So this is what happened in Lucas's case. So speech protected by the First Amendment may not be criminalized. Therefore, did the district court abuse its discretion when it failed to evaluate the prosecutor's evidence under First Amendment standards? They say yes. And third, probable cause is described as evidence sufficient, satisfying all elements of the crime, to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the defendant's guilt. However, the Court of Appeals had a different standard. So was the Court of Appeals in error when it sua sponte, meaning on its own. What that means, sua sponte means it was the court's own doing, as opposed to if the prosecutors had moved to say this standard should be applied. No, the court made up this standard all by itself. So when the court, sua sponte, applied a much different and lower standard, that of impossibility of guilt. Gotta keep my mouse cursor over the PDF so I can scroll down. All right, so let's explain the case here. This is what the Supreme Court's going to look at. So if you're new to this case, as the Supreme Court would be, probably, this is their summary. Defendant Gerhard is charged with threatening an act of terrorism contrary to MCL 750.543M. That statute is facially unconstitutional, should be declared the same by this court, and he should be freed from prosecution under it. Even ignoring the statute's patent unconstitutionality, it was abuse of discretion to bind him over for trial on that felony charge. The prosecution in this matter is based on a single photo posted online. In a published decision, the Court of Appeals held that a triable issue for the jury exists because it was not impossible to construe that photo as a threat. In reaching that conclusion, the panel failed to properly evaluate whether a crime existed in the first place under the First Amendment, and further reduced the probable cause standard to an almost meaningless level. These errors must be corrected so as to prevent their perpetuation. So now the facts of the case. Defendant Lucas Daniel Gerhard was a criminal justice student at Lake Superior State University in Sault Ste. Marie, Michigan. As Lake State Laker students and alums both know, the university has a unique policy. It allows students to keep their firearms and ammunition on its campus. Many firearms-based hobbyists enjoy this feature at this public university for activities connected to hunting, sport shooting, outdoor firing ranges, and more. Defendant Gerhard was no exception, and frankly not even remotely extraordinary given the policies of LSSU. Many types of firearms are kept and stored on campus. This includes Defendant Gerhard's AR-15. And here's a citation. The prosecutor says, "What about AR-15s? Are they allowed on campus?" And the officer says, "Yes, they are." In August 2019, Defendant Gerhard came into possession and ownership of an AR-15. As an outspoken conservative and firearms enthusiast, he went to social media to proudly announce his purchase. He used Snapchat to snap a picture of his new, fully legal AR-15 together with his law enforcement training gear. In the message portion of the snap, he stated, "Taking this bad boy up. This ought to melt the snowflakes, eh? And by snowflakes, I mean snow." And there's actually the post itself. This is literally what he was charged on the basis of, was this post alone. At the end of the message, he added what is known as the winky face or blinky face emoticon. I'm pretty sure it's a winky face. Although in this particular image, it's kind of hard to see there, but that's the image. The message was sent to his friends that he knew at Lake Superior State University. It was never sent to witness Lauren Bonds, a person who admits that she was never the intended recipient and who was the prosecutor's only helpful witness at the preliminary hearing. When Defendant Gerhard arrived on LSSU's campus, he properly checked in his firearm with campus police. Nothing untoward, unusual, or improper happened. Yet, the Chippewa County prosecuting attorney thereafter charged Defendant Gerhard under the Michigan anti-terrorism statute for threatening to commit an act of terrorism, solely based on the defendant's Snapchat. After spending months in jail, a preliminary examination was held on October 7th, 2019. At the hearing, the prosecutor first presented the testimony of Sault Ste. Marie Police Officer DeGrand. Officer DeGrand searched Defendant Gerhard's dorm room without telling him about the purpose of the search. The officer also took no statements from Gerhard or interviewed any witnesses from the university. Officer Daryl Mayette, whom was DeGrand's training officer, testified next. Although sent to investigate a terrorist threat, he, quote, ascertained from Mr. Gerhard what he meant by the language of the Snapchat. He learned the AR-15 was being brought up to LSSU, which is both lawful and permissible, and that the liberals of LSSU, who seemingly dislike firearms, would have their minds melted when bringing his new firearm to LSSU. Thus, he learned that Gerhard intended a political statement. Officer Mayette wasn't able to confirm there was no threat to anyone because the fully legal AR-15 was safely and correctly lodged with campus security, fully consistent with the school policy. Defendant Gerhard did not have ready access to the firearm. In addition to the two police officers, campus security officer Kevin Chamberlain was called as a witness by the prosecution. As a representative of the university, he confirmed that student-owned firearms, as well as a large array of other items that could be classified as lawful weapons, are allowed to be first registered and then stored at the university's campus security office, including AR-15s. Officer Chamberlain did not testify that anything improper happened involving Defendant Gerhard's AR-15. Instead, he confirmed that Defendant Gerhard properly checked in the firearm and the related ammunition at approximately 8 o'clock in the morning on August 23rd, upon his return to campus following summer break. Officer Chamberlain was also asked about the snap photograph. He was made aware of a report previously made by one Lauren Bonds, there should be an S there, Lauren Bonds, to the midnight duty officer, Officer Magura. On cross-examination, Officer Chamberlain confirmed there was no concern from university officials. The university did not initiate any sort of lockdown, did not call in state police, or make any attempts to intercept Gerhard. Once again, firearms are a normal and regular part of the culture and recreational activities at this up-north school located off the last exit on I-75 before entering Canada. The other witnesses were two students from LSSU, Haley Shuster and Lauren Bonds. First, Shuster, a 19-year-old junior and resident advisor, testified that she had known Defendant Gerhard from the university via social media for nearly 2 months, with their first interactions beginning freshman year. As one of the intended recipients, i.e. a social media friend of Defendant Gerhard, Shuster testified that she questioned if it was inappropriate, but didn't necessarily feel threatened. She further explained that another student, Lauren Bonds, took a photograph of her phone containing the shared snap communication and made contact with the residential life supervisor, who suggested it be reviewed by campus security. Lauren Bonds was a 19-year-old junior and resident advisor. She identifies herself as leaning liberal. She confirmed that she was not the recipient of the Snapchat snap from Defendant Gerhard, but was the one who took a photograph of it from Haley's phone. She testified that snowflake means more like Democrats, like the liberals and stuff like that. As a, quote, leaning liberal, she was also shocked and worried by the sight of a firearm. When asked why that picture made her nervous, she said, not very poignantly, that because what's been going around within the country today, with a whole bunch of mass shootings and stuff, and it kind of made me assume that kind of as with the gun and shoot other civilians and stuff with it, the words shoot or liberals appears nowhere in the snap. Right, we saw that up above. In closing arguments, the prosecutor argued that the threat of melting snowflakes contained in the Snapchat communication provided sufficient evidence to sustain a charge under MCL 750.543M. Without evaluating the true threat standard required by the First Amendment, the district court agreed that there was enough for a bind-over. A challenge to a bind-over in circuit court was subsequently rejected. Defendant Gerhard filed an interlocutory application for leave to appeal. That means they're filing an appeal in the middle of a case, asserting that a violation of the First Amendment and related abuse of discretion in binding him over for trial. The Court of Appeals granted the application, People v. Gerhard. After further briefing from the parties, the Court of Appeals issued a published decision. The panel first rejected Gerhard's argument that MCL 750.543M is unconstitutional. Second, it found that the jury was the ultimate arbiter of whether or not Gerhard's speech was protected by the First Amendment. Last, the panel, sua sponte, altered the bind-over standard applicable to district courts at the preliminary hearing stage. Instead of following case law, holding that probable cause requires a reasonable belief of guilt, it adopted a new impossibility standard never before recognized in Michigan law. Leave to this court, this is now the Michigan Supreme Court, is respectfully sought as the issues involve a legal principle of major significance to the state's jurisprudence, and is clearly erroneous and will cause material injustice. The published opinion changes the jurisprudence of both the First Amendment and the standard for bind-over decisions at preliminary hearings across the state. This application should be granted. So those are the basic facts of the case. There's really not much more to it. So here's what their argument is. In the aftermath of September 11th, lawmakers across the country passed new laws responsive to the public's fear of terrorism. Michigan, no exception, passed Public Act 113 of 2002, which is known as the Michigan Anti-Terrorism Act. In relevant part, a person is guilty of a felony if that person does either of the following. A, threatens to commit an act of terrorism and communicates the threat to another person. or B, knowingly makes a false report of an act of terrorism and communicates the false report to any other person knowing the threat is false. So in other words, you're guilty of a felony if you commit an act of terrorism, and an act of terrorism is an act of terrorism. It's really not clear what exactly makes it something a terror threat. So here's what the statute goes on to say. If convicted, the crime carries a punishment of up to 20 years in prison and or a fine of not more than $20,000 or both. The statute further declares that it is not a defense that, quote, the defendant did not have the intent or capability of committing the act of terrorism. Now, here's how I understand this. What that's saying, this last part here, the defendant did not have the intent or capability of carrying out the act of terrorism. So what that's saying is, if I call a school and say, I'm going to blow up a bus tomorrow, it doesn't matter if I'm not actually going to and I have no intention to, right? Because I've still made the threat. That's what's important. What it's not saying is, if I joke, for some reason I would say, oh, someone's going to kill somebody or he's going to kill her. That's not a threat because I'm not conveying any intention to threaten anybody. So this is what their argument is. First, this statute itself is facially unconstitutional. States cannot criminalize constitutionally protected speech. Thus, this statute is unconstitutional. What constitutes an otherwise valid government regulation may be deemed unconstitutional if it, quote, sweeps so broadly as to impinge upon activity protected by the First Amendment. This is such a statute. And I would argue Lucas's case proves this. That the statute is facially unconstitutional is beyond legitimate dispute. And unfortunately, the Court of Appeals disagreed, so there's some legitimacy to that. But I think that what they do is grossly immoral and unconstitutional. But that's what some judges are willing to do. And as we've seen before, some men in robes, some women in robes, will totally ignore the facts and the law if it suits their political agenda to do so. Unfortunately, that's the way it is. The First Amendment only permits government-imposed restrictions upon the content of speech in a few highly limited areas. To regulate speech, a law must fit its... By the way, I'm ignoring the citations. If you want, feel free to look these up yourself. To regulate speech, a law must fit its criminal prohibitions into a First Amendment exception. Obscenity, defamation, fighting words, incitement to imminent breach of the peace, troop movements, national security, or true threats. Failure to do so renders the law criminal. Such speech unconstitutional. There's a typo there somewhere, but we understand what they're saying. Failure to tailor a law to these narrow exceptions on what's protected First Amendment speech renders the law unconstitutional. And here's the quote from this case here. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Oh, there's a footnote here. Let's see what that's in reference to. Okay, right. What I was talking about earlier about this saying it's not a defense to say you didn't have an intention. Acts of terrorism is defined as a willful and deliberate act that is all of the following. An act that would be a violent felony under the laws of this state, whether or not committed in this state. An act that the person knows or has reason to know is dangerous to human life. And an act that is intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. So that's the definition of an act of terrorism right there. An act that is all of the following. So it has to be all these things. It has to be a violent felony, whether or not committed in the state. It has to be an act that the person knows is dangerous to human life, and an act that is intended to intimidate or coerce a civilian population. All right, moving on. The statute clearly criminalizes a threat made without any intent to carry out the same. And that's this part here. I don't know that that's what that's saying, actually. I think, let's read the text of the... Okay, so it says the defendant did not have the intent or capability of committing the act. The question is, what about the intent to transmit a threat? Because that's the real question here. It may be that the Supreme Court says it doesn't matter. A truth that is okay. Here's what it says here: a truth that is a communication of serious expression of an intent to commit an act. So it's a communication, right? So this is the distinction: a communication of an expression of intent to commit an act. Black's definition of true threats embraces not only the requirement that the communication itself be intentional, but also that the requirement that the speaker intends for his language to threaten the victim. There is one, and now with this case, two published cases interpreting the statute. In Osentowski, a panel of the Court of Appeals rewrote the statute in an effort to save it. The panel, in effect, held that the plain language of the statute, specifically that it is no defense that, quote, the defendant did not have the intent or capability of committing the act of terrorism, was to be ignored. Instead, the panel judicially incorporated a true threats analysis into 750.543M. This was an improper exercise in judicial legislation. Statutes are to be construed by their own plain language. Where a statute is clearly unconstitutional, a court may not, as Osentowski did, rewrite, amend, or read it in a manner entirely inconsistent with its plain meaning. The legislature can rewrite the statute, but courts will not do so. The Court of Appeals panel below was invited to re-examine this improper judicial fix to an otherwise unconstitutional statute. It declined. The invitation is now extended to this court. Even if MCL 750.543M, as interpreted by Osentowski, is constitutional, defendant Gerhard's bind-over was an abuse of discretion. A district court's decision to bind a defendant over for trial on a felony charge is reviewed for an abuse of discretion. A circuit court's review of that discretion is afforded no deference. An abuse of discretion occurs when the district court's decisions falls outside the range of principled outcomes. A court abuses its discretion when it errs as a matter of law. As an initial matter, the standard of decision at a preliminary examination is not particularly clear. The right to a preliminary examination is established and governed by statute. The decisional standard set forth is: if the magistrate determines at the conclusion of the preliminary examination that a felony has not been committed or that there is not probable cause for charging a defendant with a felony, the magistrate shall either discharge the defendant or reduce the charge to an offense that is not a felony. Michigan court rules, which govern procedure, restates that standard as follows: if, after considering the evidence, the court determines that probable cause exists to believe both that an offense not cognizable by the district court has been committed and the defendant committed it, the court must bind the defendant over for trial. There is a subtle yet significant difference between the statutory standard and its restatement in the court rules. The controlling statute states by its plain language sets forth a two-part test for district courts to employ when determining whether a bind-over is warranted. First, it must be determined if a felony has been committed. If it so finds, then the court must then determine if there is probable cause to find the defendant committed it. The court rule sets forth a similar two-part test, albeit with a lower standard. There, a court is instructed not to first find that a felony was committed, but rather that there is probable cause to find that a felony was committed. Then, as with the statute, the court is then instructed to then determine if there is probable cause to find that the defendant committed. In other words, the problem is there was no evidence that Lucas committed any felony at all, period. Yet he was bound over for circuit court anyway. Practically, in most cases, the distinction between the two-part test is blurred. But in cases such as the present, where the very existence of a crime turns on complex questions of law, the difference is significant. Notably, the staff comment relating to MCR 6.110E disclaims any effort at creating a lower standard of decision. And the quote is, although the language rules used in describing the bind-over and discharge standards is different than used in the statute, no substantive difference is intended. As with the constitutionality of MCL 750.543M, this application also seeks to clarify the level of judicial scrutiny required at a preliminary examination. A proper application of the statute requires, first, the district court, and reviewing courts for that matter, to engage in a rigorous exploration of the First Amendment where it is implicated. Only that would prevent the legally preposterous situation that defendant Gerhard now finds himself in. Namely, that a jury has to evaluate whether his statement is a true threat under a very complex body of law spanning more than a century. That is not to say, however, that Gerhard should have been bound over even if the prosecutor need only show probable cause that a crime had been committed. Probable cause is described as evidence sufficient, satisfying all elements of the crime to, quote, cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the defendant's guilt. Below, the Court of Appeals did not apply this standard. Instead, the court applied a standard so relaxed as to render a preliminary examination nearly meaningless. The standard applied by the Court of Appeals was that of impossibility of guilt. And here's the quote. The question of whether it is impossible for a statement to constitute a true threat, not whether it is possible for the trier of fact to deem it not a true threat. This error must be corrected in the published body of case law. To the extent probable cause is the proper standard in finding the existence of a crime at preliminary examination, under its recognized meaning, the single Snapchat communication could never establish the probable existence of a true threat. The First Amendment, applicable to the states through the 14th Amendment, provides that the government, quote, shall make no law abridging the freedom of speech. As a general matter, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. The First Amendment's protection against speech is wide, robust, and a serious limitation on government prosecutors. And here's the quote from Hustler magazine v. Falwell. At the heart of the First Amendment is the recognition of the fundamental importance of the free flow of ideas and opinions on matters of public interest and concern. It also protects the silly, the dumb, and the unpopular. The First Amendment prohibits the government from dictating what we see or read or speak or hear. It is a bedrock principle that an idea cannot be prohibited simply because society finds the idea itself or disagreeable. Moreover, the government may not imprison any speaker when his speech is deemed valueless or unnecessary, or so long as an ad hoc calculus of costs and benefits tilts in a statute's favor. A prime example of these principles is highlighted in Stevens. In Stevens, the U.S. Supreme Court invalidated a federal statute criminalizing the portrayal of animal cruelty, even when the depicted act of animal cruelty itself violates the laws enacted by all 50 states and the District of Columbia. The Supreme Court explained that society can loathe and criminalize the underlying activity even when unlawful, but the government can't bar communication about it. The First Amendment has only permitted restrictions upon the content of speech in a few limited areas and has never included a freedom to disregard these traditional limitations no matter how unpleasant an unintended recipient interprets the message. Speech also cannot be controlled or criminalized based on the heckler's veto, the concept of creating restrictions on speech that stem from listeners' negative reactions to a particular message. It is firmly settled that under our Constitution, the public expression of ideas may not be prohibited merely because the ideas are themselves offensive to their hearers, or simply because bystanders object to peaceful and orderly demonstrations. All told, the First Amendment only permits government-imposed restrictions upon the content of speech in a few highly limited areas. As such, the government must fit its criminal prohibitions against speech into a First Amendment exception. Obscenity, defamation, fighting words, incitement to imminent breach of the peace, troop movements, national security, or true threats. Failure to do so renders the law criminal. Such speech this is that same typo we saw before. Failure to do so renders the law unconstitutional. The truth-it exception under the First Amendment has its roots from Watts v. United States. Watts explained that a statute, quote, which makes criminal a form of pure speech must be interpreted with the commands of the First Amendment clearly in mind, unquote. At its core, what is a threat must be distinguished from what is constitutionally protected speech. Mr. Watts was an 18-year-old individual protesting at a public rally after having received his draft classification. He was charged with knowingly and willfully threatening the President of the United States when he said, "If they ever make me carry a rifle, the first man I want in my sights is LBJ." The Supreme Court explained that statement was not a true threat and thusly protected by the First Amendment. Later, in Black, the U.S. Supreme Court further explained the standard as requiring a, quote, communication of a serious expression of an intent to commit an act of unlawful violence to a particular group or group of individuals. Black's definition of true threats embraces not only the requirement that the communication itself be intentional, but also the requirement that the speaker intends for his language to threaten the victim. In other words, the First Amendment requires that the higher mens rea, mens rea means guilty mind, it means you know you're doing something wrong. Requires that the higher mens rea of specific intent to threaten must be proven. In addition, even actual threats of violence, which are not true threats, fail to meet past First Amendment muster. Another typo. In NAACP v. Claiborne Hardware Company, the U.S. Supreme Court found a provocator's speech announcing, quote, "If we catch any of you going into any of them racist stores, we're going to break your neck," was not a true threat. The panel correctly found that, quote, there is no doubt that defendant's charge arises out of speech that defendant made, so the First Amendment applies to this matter. If there is no question that a defendant's speech is protected by the First Amendment, the court must dismiss the charge as a matter of law. Therefore, however, the panel erred in asserting how the First Amendment is to be applied. This court has the duty to apply the doctrine of independent review and conduct an independent review of the existing record. First, the panel found it incorrect that the district court was obligated to make an initial determination as a matter of law that his speech constituted a true threat. This conclusion runs contrary to the view of courts around the country that have reviewed the matter, including the U.S. Supreme Court. And of course, that's critical because the U.S. Supreme Court trumps all the other courts. So the Supreme Court says, when facts are found that establish the violation of a statute, the protection against conviction afforded by the First Amendment is a matter of law. And here again, whether or not, actually this one, that might not be U.S. Supreme Court. But anyway, it says whether or not a reasonable person would believe the statements were a true threat is a question of law. There's another case, whether the First Amendment protects the activity which constitutes the violation of the statute must depend upon a judicial determination of the scope of the First Amendment applied to the circumstances of the case. As such, whether a prosecution encroaches on constitutionally protected speech is a question appropriately decided by the court as a threshold matter. The Court of Appeals' holding further runs contrary to MCL 766.13. I'm going to look that up real quick. MCL 766.13. If a magistrate determines at the conclusion of the preliminary examination that a felony has not been committed or that there's not probable cause for charging the defendant with committing a felony, the magistrate shall either discharge the defendant or reduce the charge to an offense that is not a felony. Okay. Here, it was recognized below that in order to prosecute, i.e. being speech not presumptively protected by the First Amendment, which Michigan law actually prohibits, the statement had to be a true threat. True threats encompass those statements where the speaker means to communicate a serious expression of intent to commit an act of unlawful violence to a particular group of individuals. Individual or group of individuals. It requires that a speaker directs a threat to a person or group of persons with the intent of placing the victim in fear of bodily harm or death. At the same time, political hyperbole is not a true threat. Extreme examples from case law proves the same. In Bagdasarian, the defendant posed an online message board statements about a presidential candidate in which included the racially derogatory term "will have a 50 cal in the head soon," and shoot another racially derogatory term. So let's just, for the sake of readability, the N-word will have a 50 cal in the head soon and shoot the N-word. When charged with the federal felony to threaten to kill or do bodily harm to a major presidential candidate, the Ninth Circuit held that the statements did not constitute a true threat. This is because when our law punishes words, we must examine the circumstances surrounding to determine the significance of those words as utterance, must not distort or embellish their plain meaning so that the law may reach them. Such statements, even if viewed by some as deeply offensive, distasteful, or hinting at gun violence, does not constitute a true threat. In the absence of a true threat, the speech is protected under the First Amendment. Another extreme example is from the recent Washington Court of Appeals case of DRC. A minor in that case made statements like, "I'm gonna effing kill this bee," but I'm gonna get her killed if anything. The DRC panel held that these words were not true threats as a matter of law. Whether unintended recipients found the message alarming is not our focus. While the language used by DRC was distastefully violent, it was not as disturbing as some of the past statements held to fall within First Amendment protections. Thus, these statements were not a true threat, and the court reversed her adjudication of guilt. Using Watts, Bagdasarian, and DRC as outlining guideposts, this snap communication, in this case, fails to meet that standard by any stretch of the imagination. Unlike Ozentowski, there is no evidence of external physical acts in furtherance of a terrorist threat, i.e., material for assembling bombs. There is just one social media post. The First Amendment, and indeed our own state rules governing preliminary examinations, require far more before a citizen can be involuntarily hailed before a jury to defend the propriety of his or her speech. And that's it. That is the appeal, guys. So a couple of quick thoughts on this. First of all, this case, because of what the Court of Appeals has done, jeopardizes the freedoms of everybody in Michigan. certainly conservatives, and possibly others as well. They've established a new standard that if someone feels threatened by your speech, you can be hauled before a jury. And by the way, you might rot in jail under custody for 2 years in the intermediary. So there is legislation coming up this Tuesday. I'm going to bring the bill up right now to correct this. This is, let's see here, 5245. Let me pull it up here. This has been introduced by Representative John Riley, who is Lucas Gerhard's state representative. And we can read through it here. Now, I understand there's going actually to be an updated version of this bill introduced as a substitute in the hearing this Tuesday, which is going to make it even better. So they're amending this statute. This is, we might have kept saying 750.543M. This is the statute. This is the statute under which Lucas was charged. And in the legislation, they put the changes in bold text and strikeout. So the original language said, a person is guilty of making a terrorist threat or of making a false report of terrorism if the person does either of the following. A, threatens to commit an act of terrorism and communicates the threat to any other person. B, knowingly makes a false report of an act of terrorism and communicates the false report to any other person. Now here we are adding in the elements of a true threat. So the revised statute would read, a person is guilty of making a terrorist threat if the person knowingly, intentionally, or recklessly makes a statement that would intimidate, frighten, or coerce a victim into undertaking an action or refraining from undertaking an action, and if the statement meets all of the following. It is a threat of physical force, violence, or destruction of substantial property, and the statement was made in a manner indicating that the threat of physical force, violence, or destruction of substantial property would be carried out by the person making the statement or by other persons in concert with the person making the statement and not by an unrelated third party. And C, considering the context of the statement in its entirety, the statement would cause a reasonable person to conclude that it was meant to threaten the person who heard the statement or another person in physical proximity to the person who heard the statement with violence or damage to substantial property. And by the way, the change that is going to be made in the substitute coming up on Tuesday is to say that actually it's not just to coerce a single person's behavior. That might be assault, but that wouldn't be terrorism. Terrorism is to change policy. So it would only be if it would lead a governmental body to change their behavior. So it'll actually make it even narrower, which is what it should be, because threatening a person is assault. Terrorism is something different. This statute was written in the context of the September 11th attacks to criminalize true acts of terrorism. So there's a hearing coming up on this bill this Tuesday, the 19th at noon in the House Office Building on the 3rd floor in the Military and Veterans Affairs Committee. If you guys support Lucas Gerhard, I hope you'll come out to support him. You can turn in a card in support. You can also email the committee clerk in support. And you can also help out Lucas too, because he has been through everything. His life has been destroyed over this case. So if you want to support Lucas, just go to this link here, gofundme.com/f/ and then all in lowercase 2B485-justice-FOR-Lucas. You can see we've raised a good amount of money for him. It sounds wonderful. In truth, his legal fees have been even more than this. He's been on tether for almost 2 years now. He's had to pay an enormous amount for all of his hearings, for his appeals, everything else. And if this case goes to trial, it's going to be even more expensive. He's already spent more than all that we've raised. So if you guys can help support him, please do that. And as always, thanks for all you guys do for liberty. Until next time, this is Adam from Rescue Michigan Coalition saying peace.